26.
That-
It says that the Life Insurance Corporation of India provision has not been
The
provided.
license expiry was on 8/6/2012.
My lord.
Then?
Then, my lord, it was again, my lord, extended, but that extension order is not here. But
Obviously, it cannot be because you were not extended.
my lord. But the so cause notice.
But there is a termination. And as such, the question of extension does
Yes,
not arise.
no, my lord. After termination, question of extension.
No,
does not
no.
arise.
After, you see, your period of the license was
Mal.
till 2012.
Mal.
In the meantime, all these proceedings started because the show cause notice was issued in 2009.
2009.
So therefore, it went on, which ended out there.
Mal.
There was a litigation which
Mal.
was filed before the court and all.
Yes, yes.
So your license was not extended.
Not extended. My lord. Before extension, it was terminated. My lord, may I pray, my lord, that can it be taken up on, my lord, next Tuesday, my lord?
Hmm?
This matter can it be taken up on next Tuesday?
Why?
My lord, because I could not go through the entire facts, my lord.
What is there? The small restriction.
My lord.
Then?
Then, my lord, I need to satisfy my lordship, my lord.
What is there to satisfy? Here is a case of termination on the grounds of false. What is called?
Forgery, my lord.
Kindly come to page 66. We
Yes,
are concerned with page 66.
Page 65 is the starting of the order, my lord.
It's apparent from the fact the case that by willful understatement of the age by as
Right.
much as 24 years, so and so had violated so and by making statement that I so and so knew the proposer for law, he misled the corporation because in that case he should not declare underage by as much as 24 years. By submitting a doctorate of court full certificate, had clearly acted against the interest of the LIC. As primary underwriter, so and so failed to provide correct and full information to the LIC of India for underwriting. Here is a case of a person of 84 years have been shown as 55.
58, my lord.
The question is, on the face of it, wouldn't both look different?
My lord, I have also personally asked the petitioner, my lord. He says that he was also confused, my lord.
How can a confusion
Because,
happen?
my lord,
I would understand.
my lord.
Nowadays, we see movie actors out there who, and at the age of 70, also look something
My lord.
as 50, 55.
My lord.
58 to 84.
82 is a big difference, my lord. Even nobody.
On the face of it, it will appear.
My. And that too, my lord, I have to submit fairly before my lord, my lord. These are the persons, my lord, LIC agents are acquainted with this type of nature of businesses. So, my lord, as a one-time mistake, my lord, what has happened? I think this person has already superannuated also. My lord. This person perhaps may be superannuated because this petitioner, my lord.
Where is the question of superannuation?
Because as per the LIC, my lord, they cannot continue after the 60 years. It's maybe, my lord, that is the regulation.
No. That as per the regulation, how many years?
As per the regulation of the 1972 HS regulation, actions has been taken under the Rule 16. And Rule 16, my lord, the Rule 8 also applies because the conduct of the agent should be up, my lord, without any doubt. His conduct is, my lord.
That I understand. That is a second. Now, do you have an age for an agent?
No, my lord, agent has no.
No. So here the agency was for initially for 6 years,
Hmm.
which completed in 2012. There has been no extension beyond that, obviously, because of all this procedure. Now, he was 52 at that point of time when the petition was filed.
Right.
The petition of the year 2015, now
15.
8 years have gone by. It means now he will be 60. But whether he's 60 or not doesn't make sense as to whether this termination is right or wrong. But what is the effect of this setting aside of the termination? Could it be entitled for a fresh license? Because the license given is for a period of 3 years or 6 years, as the case may be. But could there be a automatic renewal?
No. It cannot be automatic.
So what remains in the petition after the period,
Mal.
if the license have already expired?
No, now what is their policy, my lord, regarding in this type of situations, my lord, my respected friend, may I can advise this on my lord, my lord.
Yes, what happened?
My lord, it has,
How is the license given? You have the regulation.
my lord, the regulation. Eighty-five.
Okay.
My lord, this may be very eligible. It is in the that copy is in.
Huh?
This is visible.
Okay.
It is some
New
in this state.
Mark for us.
Rule 4, my lord, the appointment of agent.
No, it will remain because of the fact that how
What?
many years you were working as an agent?
Lord, license dated
That is the initial license.
initial license. And
But
from,
since when?
Lord, this is my first license from 2009.
So you did not work much.
No, my lord, I did work, my lord, because my credentials are very good as per the
No,
report.
no,
and
no.
recommendations,
Credentials
my
are
lord.
good, but you did not work for much long period.
My lord,
Because you see, if in the event of termination of an appointment of an agent,
my,
except for fraud, The commission on the premium received in respect of the business secured by him shall be paid to him if such agent
my lord,
has continually worked for at least 5 years since his appointment,
my lord, my lord.
and policies assuring a total sum of not less than 2 lakhs affected to him were in force on the date 1 year before he ceasing as an agent, worked as an agent.
My lord, page 36 of my petition, my lord, reflects my performance from the year 2006. From it initially starts from 2006, my lord, till the date of that permit, suspension of the license, my lord, without not extending the validity, my lord. And the business which I have given is also, my lord, acknowledged by the
No, therefore,
my lord,
if it's a case of fraud,
my
then you would not be entitled to the commission. But if it is not a case of fraud, then you will be entitled. So your proceedings will remain. Now, therefore, we are to look into on the merits as to whether this court can interfere with the order
my lord.
passed by the. What is your case?
Lord, my case, my lord, in my written statement or the appeal, my lord, which I have given, my lord. My lord, may kindly turn to page 38, annex 5. My lord. Page 38, annex 5 is my reply on record, my lord. May I read over, my lord? Few pages. With reference to your so-called notice cited above, I have the honor to inform you that the state notice was received by me on so-and-so from the branch manager of so-and-so when the stipulated time of reply fixed by you was over. On receiving the state notice, I was at dilemma as to what to do as the time stipulated has already been over. While I was thinking over the matter where there would be any fruitful result if I submit a reply after the expiry of time fixed by your honor, when I was thinking about the matter deeply, my mother was suddenly become serious due to the suffering arising out of the old age ailment. Her suffering was so much that she had to be taken to the Guwahati for the better treatment. Her suffering continued for more than a month. So in the meantime, I received the final order from you dated 25/3/2009, terminating my service as well as forfeiture of the commission. As the order came to me as a bolt from the blue, I submitted a representation to your honor stating inter alia that the certificate in question was accepted to be genuine, as in all cases, my certificate issued from the school or university, etc., are generally presumed to be genuine. So far, I remember all the agents are following the same procedure, and I also followed on bona fide belief. Moreover, at the time of opening the policy of life issued of Bhavani Kolita, I found him possessing a sound health and looked to be not more than 58 years. Moreover, the LA furnished an statement that he was 58 years old. In support of his statement, he produced the school certificate in corroboration of his statement, which was attested by me as per advice of my development officer, LICI Jutnoi branch. In doing so in good faith and without malafide intention, I committed no wrong. My lord, what has happened, my lord, the insurer has provided some school certificate to the present petitioner. And the basing on the school certificate and on the, my lord, looking into the face of the person concerned, my lord, I, my lord, executed the, my lord, that insurance policy, my lord, on bona fide reason, because this certificate, my lord, was not doubted by anybody or not doubted. Because, my lord, every insurer is required to submit a document for the age proof. Later on, my lord, on inquiry, my lord, it has come to the light that those were not genuine, my lord, manufactured. But in my, my lord, respectful submission, my lord, is that my, for manufacturing of those documents, there was no role on my part, my lord.
Now,
No, my lord, basing on those documents and certificates, my lord, I did execute the policy, and those documents and certificates, my lord, has been later on only come to the light, my lord, that those cannot be treated as a genuine or some manufacturing was there. So, my lord, and in that part, my lord, that is not my intention, my lord, that I have committed the forgery. But basing on those documents supplied by the my lord insurer, I proceeded, my lord.
But in that policy,
My lord,
when you sign out there,
my lord.
you have mentioned out there that you knew this person concerned for a long time. How do you explain that?
My lord, knowing that person long time, my lord, is
Then
very,
the question becomes very difficult.
no, is, my lord,
If it is once you have come, a person has come out there showing a particular certificate that this is my age out there, and on the basis of that you have believed it and done it, it should look very fair.
my lord.
But if you have stated out there that yes, you have known this person for a long time, then
Sometime
would
can
the
be,
same
my
same
lord.
be applicable? Because here everything changes. If the policy amount, if the person is 58 years and 84 years, the policy premium would be
My
different.
lord, my lord.
And then the life risk is also would be different out there.
Different.
Now, another thing is that person concerned would also be not entitled to
Get the policy in
of the
that manner.
policy
My
if it is otherwise found that he has made a false statement
False
out
statement.
there. So that is another aspect of the
My-
matter. But
But my role, my lord, my role.
But
yes, my
your
lord.
role, if you have made that statement in the policy, in
My-
that form, that yes, in this case, this has happened, that you have stated that this is for a long time
For
you
a long
knew
time.
it, then what's the case you have?
My lord, yes, my lord, that is a, my lord, mistake perhaps done by me, my lord.
That is not a mistake, that
My
is a huge mistake. Then why? So under what circumstances this court should now
My lord.
stand on it, unless you say on the ground of proportionality? You develop your argument on the principles of proportionality, then the question becomes different.
My lord.
That this is the harshest punishment which otherwise should have not been given. You have to develop your argument on that.
My lord, some time is given, I will try to satisfy my lord, my lord, with some judgment also, my lord.
What judgment?
My lord, our High Court has also, I have not gone through the entire judgment. That time, my lord, I am asking.
This is a 2015 matter. You have been dealing with this matter for last
My lord, what is-
the 2000 and from 2012 onwards.
that is correct.
And
my
I see your name appearing in all the
lord. No,
orders.
my lord,
being passed.
I am conducting the case, my lord, but what has happened? my lord?
Then what else? What further
My-
time is required?
No, my lord may keep it as a part heard.
I don't require this to be kept as a partner.
My lord,
I have many more matters out there. But
My-
the fact is, otherwise, why should this
my
court
lord, that
interfere
person has been
with the decision making process? Unless, yes, it may be a case of proportionality. Yes,
Regulation 8B very specific.
no, their regulation is against
And
me.
power exercise under the regulation by the competent.
8B.
Any regulation there is no pleading that the regulation is wrongly applied. 8B, my lord.
Agents
Make reasonable inquiries in regard to the life of the incident.
could take the total expected heat it 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 at the yes, you have the record. Why?
Records are not called for. Records are not called for.
Okay, bring the record. You develop your argument on that.
My lord.
So you don't have. Oh, this policy is there. Wait. Policy is there. $58.
Yes, my lord. In my affidavit, I have it. Page pattern.
And what is the basis of on which you have uh, proposed this? The age was calculated.
Milord, the certificate which we produced is a page, Milord, 10 annexure R1, Milord.
R1 is there.
Yes, Milord, annexure R1, page 10 of the affidavit, Milord. The certificate issued by the headmaster of Hekra High School, Milord. It's on December 1958 to 28, date of birth, if it's good.
When was this the date of the certificate?
The attendance register was 12 years, 12 years, Milord, no, 0 months, 0 days. Is the
Now, what is the date of this certificate?
date of the certificate, Milord, is
There's no date of the certificate.
yes,
What type of certificate? And how did you find out that it is 84 years?
Page 12, my lord, the certificates are found cheap.
You refer that the certificate. Agent. This was done in 2005,
My lord,
and it was found that at the time of his death,
Hello.
this person concerned was 82 years.
and then my lord, Gaugura certificate is also there. Page 16.
Page?
16, 1 6.
That is the AFI where it has been shown as 82 years. But where has it stated out here?
in this proposed form.
And why there are two certificates out here, Annexure R1 and R2?
It is my lord, Timothy Poroma Kolita, daughter of Bhavani Kolita. Her is, he was reading in class 9 in the year 1980.
So how do you link? What is the link between them?
The certificate is given, my lord, page Excerati. I para page 3 of my para 4 is my lord, statement.
Yeah, page 79, page 13. How long do you know the life proposed?
Because
Since long. So you will be knowing if it's a false.
It's from, Milord, take you from how long? 1 year, 2 years, 3 years.
So then also 1 year, 2 years, 3 years also,
Fine.
maybe 1 year also you will be knowing it.
Fine.
If this person concerned is this.
Lord, Lord, even I do not even my case is going to be dismissed by my lordship. Lord, I have to submit fairly. Some forgery is there, my lord. But that forgery, my lord, who has committed that forgery? That is the question, my lord. My lordship may be pleased to decide, my lord. Because, my lord, what has happened, my lord? I have asked the present petitioner that how you execute or send the proposals. They said mainly we rely on the documents produced by them, school certificate or other documents. No agent, my lord, goes to the school to verify that whether the certificate exhibited or produced by an insurer is a genuine or not, my lord. Basing on that, my lord, and my lord, what has happened, my lord, against a policy, my lord, we get some commission, my lord. That we get a commission, my lord, when we propose something, my lord, by taking the LIC agent, my lordship is well aware, my lord, they are always behind us, my lord, that let's us open a policy, my lord, that the policy they get a commission. So that is the, my lord, may perhaps the mistake committed by this person that basing on relying on the document and on the face value of the person's, my lord. My lord, I have asked that how you have do the such mistake. 88 years and 50 questions that the person looks so young like that, my lord, and I do not have that expertise to go into the deep that the what would be his actual age. I have to go by the certificate. That was the situation at that relevant period of time.
Was this document made a part of the document when you filed it?
My lord, along with the proposal.
Uh-huh.
Yes, yes, yes.
This document
This
was
doc-
there.
because that's why they have got the access of this document. Thereafter, my lord, when the LIC authority doubted regarding the age, then they have done the verification from their end. Not only me.
Now, they did the verification after the claim must have been made in
Yes, yes,
2006.
yes, my lord. Yeah, and what
And
has
then
happened,
they
my lord?
found out in 2007
My,
that the certificate was a fake certificate.
my lord. And secondly, my lord, the branch manager and other person's recommendation is also required, my lord. It is not that only myself is the person who is only responsible for, my lord, sending the proposal. The other higher officials are also there. My lord,
How is the policy made?
My lord, with regard to that submission age, regulation 8 is that is why my lord, the provision has been kept in regulation 8B.
my lord. Yes,
That
yes,
is why
my
you
lord.
have to
And
satisfy
They
the
take
age.
all reasonable steps to ensure that the age of
Exactly,
the life
exactly.
insurance is admitted at the commencement of the policy.
That my lord,
Reasonable
with regard to
steps,
premium, my lord. Because I am the age is main.
No, you see, 100% you have not released that. Did you honor the
No, no.
policy? No.
No.
Did you honor the policy?
No.
So you did not honor the policy because of the fact that there was a false statement being made. So that is aspect. So there is no loss to you.
Yes.
As of now, there is no loss
Right.
to the LIC. But the question is
Right.
whether this aspect would be proportional. The principles of proportionality nowadays play a very important aspect to the matter
My lord.
on the question of punishment.
Right.
Yes, you may not renew the license. You may term it. He not be attacked on the ground of fraud being removed. The commission which he has given. So that is an aspect which requires
Right.
to be taken into
I
account.
I am.
Yes, you may not may give him a policy, the agency any further. That is your. But would it be so? Is it doesn't this amount to the harshness of the punishment, taking him everything? It is a different thing. He had a particular document. Yes. The question is it mandated out there that that document has to be verified? Now, if you apply those Supreme Court judgments on the question of fake driving licenses,
Yes.
if you see the fake driving licenses where the insurance
Yes.
sometimes say that no. But the question is whether the owner of the vehicle in question is required to go to the RTO and make the search as to whether the document is fake or not before appointing a driver.
In that case, my lord, that is why pay and recovery provision.
No, that is another aspect. But the Supreme Court has categorically said that it is not the duty
Duty.
of the owner of the vehicle
Right.
to go to the RTO and make these the verifications out there. That is what the Supreme Court has
Yes.
said. Now here, He has produced a certificate that as on that date he is 58 years or something to that effect. This is my transfer certificate. I've read only till class 5. Can you say, or is it mandated in your regulation that he has to cross-verify this before submitting the proposal before the authority, the certificate? Is it the mandate? It doesn't show so. Here, he's only to take reasonable steps. The reasonable steps, would you say that he needs to go and verify the authenticity of the vehicle, the authenticity of the certificate?
Then, my lord, if I know a person since,
And if that be so, then produce it on the next date that is required.
my lord, if I know a person since long, then my lord, 84 and 58, my lord, that agent rule is that they know the people of the, from who they are taking the risk. I just, yes, definitely. Agent is physically, my lord, agent is a person, physically is taking. And since long, if the declaration is there, then my lord, a 58 and 84, my lord, 84-year person, 58 years, and knowing that person long.
And he died the next year.
My lord, next. That is what, my lord, the fraud comes in the mind of the, my lord, agency, LIC. That is what, my lord, these types of situations are going on. Many cases happen. They take this because they know that man is bedridden. He may die at any. Things are going on. In the Corpeta also, my lord, many fraud cases, LIC detect. For the purpose of the claim only. Bedridden person take the risk, then after 6 months or 8 years, if dies,
Let us see what is the reason you say on the question of appearance. Is it on the question of appearance you could have made out? Is that your reason in your appellate order or in the order? Or is it on the ground that a fake certificate was taken?
my lord, what is declaration in the statement given? That is verified by the agent. If that declaration is wrong, that the agent could take the responsibility. Because the regulation is saying,
No. Maybe wrong. He's only to take regular reasonable steps. The reasonable steps he has taken
that
on the
is-
basis
that
of the
is what
certificate.
Once declaration that the agent knows in its law. That's my lord.
Earlier, Justice Rishikesh Roy had passed an order for reconsideration in
my
view
lord,
of
the,
this. What has happened thereafter?
Thereafter, my lord, the order has been passed. That is the order at the petition and.
Then also another order was passed just saying that we have looked into it, we are not satisfied. Then an appeal was again, another petition was filed that there is no reasons given.
Right.
And therefore, this is the second.
Right.
And
Third
that is the order of Justice Monojit
Yes,
Bhuiyan.
yes.
And again, and pursuant thereto, this order has been passed.
Right.
By which you have been, now you have given reasons out there.
Yes.
1, 2, 3, 4.
Yes. Page 65. Right.
But you see, please kindly come to page 60. Kindly come to the reason number 3. By
Is it-
submitting a doctorate or a false school certificate, had clearly acted against the interest of the LIC. Are you saying that he manufactured it?
That was detected later on when the death claim.
No, no. Are you saying that he manufactured that?
No, that person who took. That is what my lord.
Therefore, no, by submitting a doctorate certificate, Mr. So-and-so had clearly acted against the interest of the LIC. So is it the mandate out there on your part that he requires to, every agent is required to cross-verify the age certificate with the authorities concerned?
No, that is that regulation does not mandate, but regulation mandate.
Then how will he know?
My lord, regulation mandates, my lord, at the initial second paragraph, what the competent authority has done, 1, 2, and 3 of this page, serial number 2, the competent authority relied on the regulation 8.2.
Hmm.
That is what that 8.2.
Yes,
That-
it too,
that-
I've seen it.
Yes,
It too, you see, we are concerned with C. He says, take all reasonable steps to ensure that the age of the life insured is admitted. Make all reasonable inquiries in regard to the life to be insured before commenting proposal for acceptance, and bring to the notice of the corporation any circumstance may adversely affect. Now, is it supposed when a certificate has been produced before him, is he supposed to know the authenticity of the
that is
certificate? Because otherwise, you already have a right that if there is a breach
Yes.
of the proposal, then in that case, you are not going to grant him the benefit of the policy.
Yes.
That you have done.
Yes.
And as such, you must have 100% not giving the benefit out there.
Right.
So under such circumstances, in this case, if the petitioner is not required to verify with the authority from who produced the certificate,
that is where my humble submission is. That is why a proposal form provision has been kept. How long you know? Because the agent should know that person. The life is the agent. We have to LIC to take a life, risk of a life. If the life is such a age, that is what that column has been made. How long you? Because we rely on the agent.
now you talk about regulation 9.
Right.
You mandate that the agent has to give so much of business.
That is there.
Now, how are you supposed, is the agent supposed to cultivate a relationship, just for example, in the year 2022, and only in 2024 do it because now I know him for 2 years. So think how to interpret, because here you are required to come up, do proposals or submit your proposals out there or bring insurance, minimum business you have to bring. How do you bring it? And if you don't bring it, you put a penalty upon him that you are not going to regularize.
That is why professional deeds that should be. Agent one, agent
So
keeping
how do you mean?
that professional.
What do you mean by since long?
These
You may know him for a month.
these professional hardships they have to face them, because it is that professional hardship they have to face. They have to keep take the risk of a good life, keeping in the profession of the first life is the premium will be like that, and there is a probability that after procuring the policy, this life may not go long. This they have to take and accept that they have to also take their business in mind. That is what the regulations provisions have been kept, so that LIC should not be do that. And if
No,
the-
here the LIC is not in loss. In this,
I think probably lot of on disproportionate part, but it
only on the question of this.
Yes. Yes.
Because if we see, there was a direction by this court earlier that whether it would be disproportionate or not. Now, thereupon, the order does not say anything. And as such, say that we have looked into, but we feel this is the punishment to be given. Then the matter comes up before Justice Bhuiyan. Justice Bhuiyan passes an order that this is not a speaking order. Now you have to go on the question of speaking. Now, in speaking order, you give these reasons. But how do you take care about the disproportionate thing?
that part has not been dealt in the speaking order. I have
Then isn't that the requirement of Justice Rishikesh
Yes.
Roy's or the
yes,
order?
Yes,
Then
that required. Disproportion, but at least because
if you have not taken note of
only-
that,
only my lord, probably that competent authority only take the reports of the regulations.
understood, you
That is
take it.
that regulation part.
There
of the
is
state.
no, but the question is, you are to decide as to whether it is proportional. You are to give your reasons to that, more particularly in view of the order. Can you keep that? Order.
Page 57.
Can you see by page 59? In view of the above conclusion, I direct the appellate court, that is the zonal manager of the LIC, to reconsider the punishment by taking account of the recommendation of the senior manager of the Dudhnoi branch. The impugn order for termination of agency and forfeiture of commission will abide by the fresh decision to be rendered by the appellate authority. Now, finally, see, paragraph third. In the case that neither the disciplinary authority nor have considered the recommendation for reinstatement made by senior of the concern, and I feel that this aspect ought to have been considered by the two authorities. This was necessary as termination leads to a loss of livelihood and forfeiture of the resulting in stoppage of the earnings, which was otherwise due to the business generated by the LIC. Therefore, the proportionality of the penalty ought to have been considered.
That is,
Now, where is your consideration?
that is not that matter.
So,
That
we direct the authorities to again consider.
on that portion.
Yes, I'm not,
Yes,
but only on
and,
that. Too.
that is my rule 19 has been probably by exercising power under rule 19 with regard to the forfeiture of the police
What is Rule 19?
rule 19.
No. Rule 19, if it's the termination of an appointment of an agent except for fraud. If it's a case of fraud, it is very well.
Right.
But the question is, you have come to a fraud on the basis, if you see number 3, only on the ground that he has mentioned that it is since long. But your regulation does not say, it says only a reasonable measure. Your regulation does not say that he has to make a verification with that particular document.
Yes.
So you need to consider that aspect of the matter. You dispose it off.
Mal.
You want time?
No, my lord.
Judgment. Heard Mr. A.R. Bhuyan, the learned counsel appearing on behalf of the petitioner.
Yes, not. Yes, not correct.
As not, the learned counsel appearing on behalf of the respondent. The petitioner hearing have a sale. The termination of his agency and the forfeiture of his commission. And thereby have challenged the various orders, including the order dated 25/3/2015. From the materials on record, it reveals that the petitioner hearing was issued an agency license in the year 1997. During the course of time, the petitioner claims to have obtained various policies and rendered business policies and rendered business to the respondent corporation. The entire dispute arises on account of a policy being made of one Bhabani Kolita, since deceased. The report reveals that one Bhabani Kolita had approached the petitioner for a life insurance for a policy amounting to rupees 50,000. As a proof of his age, late Bhavani Kolita produced the certificate from the headmaster, Hekra High School, wherein it was certified that the said late Bhavani Kolita was 12 years as on 31/12/1958. On the basis of the said certificate, the petitioner submitted a proposal stating inter alia that he knew the late Bhavani Kolita since long, but on the basis of the said certificate and the proposal submitted by the petitioner, an insurance contract was entered into by the by on behalf of entered into by and between late Bhavani Kolita and the respondent corporation. When was this?
Two thousand five. 30 March 2005.
Huh?
30 March 2005.
On 30/3/2005. Subsequent thereto, on 18/8/2005, late Bhavani Kolita expired. On the basis thereof, a claim was made. On the basis of the policy, a claim was made. And a death certificate of the Gambura was placed before the respondent authority corporation, dated 17/3/2006, which clearly showed that the age of the petitioner, age of late Bhavani Kolita at the time of his death, was 82 years. On the basis of the said claims were made, the respondent corporation initiated an inquiry in terms with Regulation 23. Regulation 23, in terms with inquiry. Against the petitioner. By issuing a show cause notice on 3/3/2009. It is also relevant to take note of that prior to the issuance of the show cause notice, inquiries revealed that the certificate on the basis of which the insurance, the insurance contract was entered into was a fake certificate. It was certified by the principal of Hekra Higher Secondary School, stating in the area that the said certificate were not issued by the said institution. The petitioner submitted the so-called reply, and pursuant thereto, an order was passed when
25 March 2009.
no, after the so-called reply
Yes, madam. That is at page 32.
on 25/3/2009. On the basis of the said order, well, pursuant to the said order, in terms with the said order, the petitioner's license, agency license was cancelled, terminated on the ground of fraud, and further, there was forfeiture of all the premiums, forfeiture of
Commission.
the commission in terms with Regulation 19 of the Life Insurance Corporation. Regulation, the Life Insurance Corporation of India, bracket Agents Regulation 1972, for short, that regulation. The petitioner duly submitted the representations before the Senior Divisional Manager, Life Insurance Corporation, Bongaigaon Divisional Office. However, to no avail. Thereupon, the petitioner filed an appeal on 22/10/2009 before the respondent number 1 in terms with Regulation 23 of the regulation. The said appeal, which was filed by the petitioner, was forwarded by the respondent number 3 to the respondent number 1 with a recommendation for reinstatement on the ground that the petitioner is a productive agent. But unfortunately, due to one fake policy submitted by the petitioner, by the policy holder, he was held guilty. And it was not an intentional act on the part of the petitioner. Subsequent thereto, an order was passed on 11/1/2010, whereby the appeal of the petitioner was rejected, thereby upholding the termination order dated 25/3/2009. 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 2009 . 20 Being aggrieved, the petitioner approached the court by filing a writ petition, which was registered and numbered as WPC number 3422/2010. On the ground that the said order was passed, appellate order was passed without giving an opportunity of hearing to the petitioner, and also not taking into account the recommendations so made by the respondent number 3. The said writ petition, that is the petition number 3422/2010, was disposed of by an order dated 16/10/2014. Observing inter alia that neither the disciplinary authority nor the appellate authority had considered the recommendation for reinstatement made by the senior branch manager of the concerned branch, which was a relevant aspect of the matter which ought to have been considered by the review authority. It was also observed that the said recommendation ought to have been taken into account, in view of the fact that the termination of agency leads to loss of livelihood, and forfeiture of the commission results in stoppage of earning, which was otherwise due to the business generated by the LIC. It was therefore observed that the proportionality of the penalty ought to have been considered by the authority by taking note of the recommendations made by the senior branch manager on 22/10/2009. In terms with the said observation, directions are accordingly passed, directing the appellate authority, that is the zonal manager of the LIC, to reconsider the punishment by taking into account the recommendations made by the respondent number 3. It was further observed that the impugned order paragraph number 7 and 8 of the said order being relevant is quoted hereunder. Thereupon, the record revealed that on 3rd of December 2014, the zonal manager, that is the appellate authority, passed an order holding inter alia that as the agency was terminated due to fraudulent activities which detrimental to the interest of the corporation as well as the public, the order of termination dated 25/3/2009 was upheld. From a perusal of the said order, which have been enclosed as Annexure 11, it reveals that there is no reasons assigned, or for that matter, there is also no consideration as regards in terms of the directions passed by this court. On 16/10/2014 in deputation number 3422 of 2010. The petitioner thereupon, being agreed, challenged the said order dated 3/12/2015 by filing a petition before this court, which was registered and numbered as WPC number 492/2015. This court, by an order dated 4/2/2015, disposed of the state petition. Observing that the order dated 3/12/2014 was not a speaking order and was also not in accordance with the order passed by this court in WPC number 3422/2010. Accordingly, the order dated 3/12/2014 was set aside with the direction to the appellate authority to look into the matter once again and pass a speaking order entirely in terms with the order passed by the court in WPC 3422/2010 as expeditiously as possible within a period of 2 months of the state order. Thereafter, the impugned order was passed on 25/3/2015, which have been put to challenge by way of the instant retreat. I've heard the learned counsels on behalf of the people, as well as the learned counsel appearing on behalf of the respondent corporation. This court have also perused the materials and report, including the impugned order dated 25/3/2015. From the impugned order dated 25/3/2015, the appellate authority observed that by willful understatement of age by as much as 24 years, the petitioner had violated Regulation 8(2)(b) of the regulation. It was observed that by making the statement that the petitioner knew the proposer, inverted commas, for law, the petitioner misled the corporation as he ought not to have declared underage by as much as 24 years. Further that, it was observed that by submitting a doctorate of course full certificate, the petitioner had clearly acted against the interest of the LIC of India. And the petitioner, being a primary underwriter, failed to provide correct and full information to the LIC for underwriting the risk. On the basis of the same, the appellate authority again confirmed the order dated 25/3/2009. This court have duly taken note of Regulation 8(2) whereby the functions of the agents in procuring new life insurance business have been stipulated. The said Regulation 8(2) is quoted herein below. From the above regulation or above quoted regulation. It would reveal that the agent is required to take into consideration the needs of the proposer for life insurance and the capacity to pay premiums, semicolon. Make all reasonable inquiries in regard to the life to be insured before recommending proposals for acceptance, and bring to the notice of the corporation any circumstances which may adversely affect the risk to be undertaken, semicolon. Take all necessary steps to ensure that the age of the life assured is admitted at the commencement of the policy, and not interfere with any proposal introduced by any other agent. From a perusal of the same, from the above Rule 8, Regulation 8.2, there is a requirement that the agent concerned makes necessary inquiry in regard to the lives to be insured before recommending proposal. But the question arises as to what would constitute reasonable inquiries. In the opinion of this court, the reasonable inquiry to be made has to be taken into account in the touchstone of the principles of Wednesbury reasonableness. In the instant case, it will be seen that the certificate was placed before the petitioner. The regulations does not mandate that the said regulation that the certificate is required to be verified with the authority concerned before making the proposal. What is required is for a prudent person to make the necessary inquiries. As to whether there is any notification, as to whether there is any, whether the regulation or for that matter, there is any notification issued by the respondent corporation that the 8 certificates so produced is required to be verified by the agent with the authority issuing the said certificate before submission of the proposal. And secondly, as to whether the insurance contract made with late Bhavani Kolita was honored in view of the false declaration so made. The learned counsel appearing on behalf of the respondent submitted that to his knowledge there is no such notification which mandates notifications or orders of the respondent corporation which mandates that the agent is required to make verification of the certificate of the age certificate with the authority with the issuing authority prior to submission of the proposal. He further submitted that the insurance contract with late Bhavani Kolita was not honored in view of the false declaration. This court also cannot be unmindful of the fact that the senior manager, that the respondent number 3, who is the senior manager, senior branch manager, branch manager of the Bongaigaon branch, had also given a certificate that had made a recommendation to the effect that the petitioner is required to be reinstated on the ground that where is that?
Lord, is that page 50, my lord? Page 50.
Where he had recommended that the petitioner is a productive, is very productive, but unfortunately, one policy was found but unfortunately, due to one fake policy submitted by the policy holder, he was held guilty, and that there was not an intentional act of the petitioner. The respondents in the affidavit also have not stated that there are other policies also in the affidavit have not stated that the petitioner was a habitually the petitioner have been found guilty in respect to any other policy of the petition. In respect to any other policy wherein the petitioner had submitted the proposal. This court have also taken note of that the appellate authority had placed great reliance on the aspect that in the proposal so submitted by the petitioner, he had mentioned that he knew the proposal for long. The question, however, arises as to what would be the interpretation to be given to the aspect for long, more particularly taking into account Regulation 9(13) of the regulation, which stipulates that the agents are required to provide certain required to provide business and non-providing of the business would entail termination at the end of such year. This court further finds it relevant to observe that the penalty which have been imposed upon the petitioner is not only a penalty for the purpose of termination of his agency, but also forfeiture of all commissions which he would have otherwise earned. This punishment touches on the right of life, touches on the livelihood of the petitioner. It is well settled by various judgments of the Supreme Court that the principle of proportionality involved inverted balancing test and the necessity test inverted commas. The balancing test permits scrutiny of excessive and onerous penalty or infringement of the right or interest and a manifest imbalance of the relevant consideration. The necessity test requires infringement of the human right to be to the least restrictive alternatives. In this regard, this court finds it pertinent to take note of the judgment of the Supreme Court in the case of Kerala State Beverages (M&M) Corporation Limited versus PP Suresh and others, reported in 2019, 9 SCC 710, and more particularly the paragraph number 31, where it has been stipulated when an administrative act decision can be said to be proportional. The same is quoted hereinunder. In the backdrop of the above, if this court now takes note of the impugned order dated 25/3/2015, it would be seen that the respondent authority, more particularly the appellate authority, did not take into consideration the question of proportionality of the punishment, more so when this court, in its order dated 16/10/2014, passed in WPC number 3422/2010, had directed the appellate authority to look into the same. Under such circumstances, it is the opinion of the court that the impugned order dated 25/3/2015 not only is contrary to the directions passed by this court in its order dated 16/10/2014, but also does not take into consideration the necessity, the balancing test and the necessity test as observed by the Supreme Court in the aforementioned judgment. Consequently, the impugned order dated 25/3/2015 is set aside and quashed. The appellate authority is directed to reconsider the question of the question of the punishment on the basis of the observations made herein above, and more so, taking into account the observations of the Supreme Court in the judgments in the case of Kerala so and so Supra. The same be done within a period of 3 months from the date a certified copy of the instant order is served upon the respondent number.
One.
Alright.
Obliged, my lord, highly obliged.
Yes, take this. You may require.
Item 3.
Lordship, with an apology, I seek a short accommodation for it, my lord.
Why?
My lord, we mistook it for some other matter and we missed the file. So,
Don't wait. Have to take it back.
my lord, may then kindly
What are you
sit in the,
challenging? What are you challenging?
but if I do not have the file at all, if my lord may kindly fix it at 2, after 2, if possible. We'll get the file till then.
We also don't have the game here. Oh, you are there. Yes, what is it challenging?
I do not have the record, my lord. I think with the assessment has not ordered in Chile.
Huh?
Assessment order has been challenged.
Assessment order, I can tell him so they can fix the
Increase an assessment order.
Why you not filing any appeal?
Yes, my just and will taken in the affidavit, my lord, under section 204.
Yes. The appeal has to be filed.
Yes.
It's not going to look into it, that the amount is higher or less. File it out. Write it out with them. Is a stay. Is a stay or not?
Let us take the order, my lord. But there is a provision of will under section 204. That is the stand of the affidavit.
Interesting. Say on 11/9/2015, prayer for interim order shall be considered on the returnable date. Then the petitioner is aggrieved by the exorbitant hike of the property tax by the Guwahati through the impugned notice stated so and so in respect of it. However, Mr. A.P. Chaudhary, the learned senior counsel appearing for the GMC, placed for 2 weeks' time is done. Mrs. M. Majumdar, the learned standing counsel, Guwahati, was placed for 4 weeks. Interim order passed earlier shall proceed. There is no interim order. So what remains? Nothing remains. Okay, 2 o'clock.
Obliged.
Get a copy of this.
Item 4.
Very
I am for the respondent, Lordship. I
This
think this
matter
has
is
become
infractual.
infractual.
This matter is infractual.
And it comes to appearing, counsel appearing at the bar, subject to the taking back up the bar, and close as had become. There is no interim order.
There is no.
Item 5 and 6.
Yes, my lord.
Not this writ petition challenges 2 orders passed by the Transport Commissioner of the state and a transport officer of Dibrugarh, whereby they banned the registration and sale of all 4-wheeled motor vehicles purportedly pursuant to an order passed by this honorable court in a public interest litigation.
Oh, that one. That
M1,
Yes,
that's
my
it.
lord,
The
yes.
quadricycle
Please.
case, The
Sridhar Rao was
intention,
there.
the order of the division bench in the PIL was for quadricycles, really speaking, which had been separately categorized, although they are four-wheel vehicles and have a mass of 1500 kgs. But these tests, crash tests and the emission tests were not being followed by them. Therefore, the division bench in the PIL had directed that unless the crash test and the emission tests were carried out, they should not be registered. Misreading those orders of the division bench, the transport commissioner passed a sweeping order saying that no four-wheel vehicle will be registered in the state of Assam. So therefore, we had
But
filed.
that judgment is not, the PL has been dismissed.
Yes, PIL has ultimately
So
been
what do you mean?
dismissed. So the whole basis of that order of the transport commissioner goes on this also. There is no foundation for the order. Anyway, it was contrary to what the
Now-
court
now
had
what
said.
is that? Now you are
Lordship,
allowing
without crash test, we are not allowing. Crash test have to happen. We are not
that crash test is required under what?
crash test, for registration, Lordship, all these are required.
You need the certificate that
Yes, yes.
What?
Yes, certificate,
they must have had the certificate.
if they have certificate, we have no objection.
So therefore,
This
they
is
started
the-
registering
I
immediately.
remember, because I was there in the PI.
PL,
Yes,
my lord.
Yes,
I remember the essence of there has to be a certificate that yes, this type of vehicle have gone through a PF practice. And for it, if it has been gone through this particular certificate, that given to a
Correct.
that they did.
correct. Rule 126 of the motor vehicle rule says that every prototype of a vehicle, whether it is a quadricycle or any other vehicle, has to be tested by some statutory authorities, ARI, etc. And they give a certificate that they comply with all the standards laid down in the country. So if you have those tests, if you cleared those standards and you have that certificate of clearance of the prototype, the manufacturer also under Rule 127 has to give a certificate that we comply with all the rules and standards. So
Yeah.
all those certificates were with the authorities. In spite of that, they stopped the registration. That was the grievance in this writ petition. Therefore, an interim order was passed on 24th
2015,
August
my lord.
2015.
That-
Yes, para 8 is the relevant paragraph where they said if the transport commissioner finds that some vehicle does not have those certificates,
Without the state, it could- So your submission is the vehicles which are there, having undergone the crash test, the prototype vehicles which have undergone the
Yes,
crash test,
yes.
and few certificates have been granted.
Yeah.
The question of the registration being stopped does not arise,
does not arrive.
because it is in conformity with the central motor vehicle.
Absolutely. So therefore, these orders had to be quashed. In any event, now that order was based on an interim order in a PIL. That PIL itself has been dismissed and the interim order merged. So therefore, that way also those orders can't stand today. And those orders, the two impugned orders have to be quashed.
Lordship,
Yes, my lord.
Page
The
37.
two impugned orders, your lordship would, first order is on
37,
page
my lord, that I
35.
7, my
Page,
page 37.
No, page, 1 minute, page 35 is the first order by the transport commissioner.
the other one is,
Other one is at page 37, which was filed.
page 37, I have read it. The
Yes,
other
page 35, page 37 is the other one by the transport officer Dibrugarh, which followed the earlier order and also passed similar order. 35 and 37 are the two impugned orders.
Here's your name,
Sandeep Narayan.
Mr. Sandeep Narayan, the council appeared after. And Mr. R. Sharma, who is appearing for parties to the,
No, I'm assisting.
you are appearing. The D dot, DJ dot. D dot or DJ?
What?
The D dot. MD for the learned static out,
Transport department.
passport appears on and it's MD for the learned council appearing on behalf of the trans. Both the petitions have been filed challenging the deputy message dated, what is the date?
6th August 2015,
6th August 2022 by the
The-
Joint Commissioner of Transport Assam,
My lord.
as well as the
7th August 2015,
the
issued by the Transport
office
Officer
order
Dibrugarh.
dated 7/8/2015 issued by the District Transport Officer, Dibrugarh, Assam. From a perusal of the impugned WT message as well as the office order, it reveals that the said orders were passed in pursuant to certain directions, certain interim directions passed by this court in PIL number 42 of the 2015 and 38 of the 2015. It has been stated at the bar that the state PIs in the meantime have already been dismissed by the learned division bench of this court, and the state interim orders have also lost its force accordingly.
Dismissed on 20th April 2018. I have the order, my lord, may take it.
And the interim orders have also lost. So, be that as it may, it has also been submitted by the learned counsels appearing on behalf of the petition that the manufacturers of the vehicles which the petitioner in WPC number 4994 of 2015 represent, as well as the petitioner in WPC 67 of 2015 have duly complied, duly complies with the crash test, only the crash
And emission,
test.
and emission.
and emission tests. And such reports are duly submitted before the concerned authority. So, Mrs. M.D. Bora, the learned counsel appearing on behalf of the Transport Department, submit that whenever a vehicle, if a vehicle is required to be registered, it is the requirement that the said vehicle conform to the Motor Vehicle Act 1988 and the rules framed therein. The Transport Department of the Government of Assam has no objection in registering such vehicles which duly conform with the state act and the rules. So, taking into account the above, this court disposes of both the petition by setting aside and quashing the WT message dated 6/8/2015, as well as the order dated, office order
Seven.
dated 7th of August 2015. And further directing the respondent authority to carry out the registry subject to compliance with the provisions of the Motor Vehicle Act as well as the rules framed therein.
Please.
Yeah, please, my lord.
Item 7.
Please,
Yes, what is it?
my lord, kindly peruse the order dated, my lord, 11/2, my lord. A learned friend stating that in the earlier occasion, stating that, my lord, retable, another retable pending, my lord. What? Before the division bench, my lord.
What are you
Let-
challenging? Let us
By this repetition, my
allot
lord,
the fresh plot of land to the victim family of the and it will be allowed of yes,
Here, my lord, we have filed our affidavit. That is in a nutshell, my lord, that it way back in the year 1996 to 1998. My lord, the serious magnitude of my lord ethnic clashes and ethnic violence occurred in the district of Koplagar, in the city area.
is a pity.
And then, my lord, a lot many people were displaced. And so, my lord, in order to give them appropriate relief to rehabilitate them, the government of Assam formulated a scheme. And that scheme was worked out in 4 phases. And defined categories of persons were earmarked who were entitled to the grant of relief and rehabilitation. And my lord, as a part of the scheme, one category of persons was entitled to a gross amount of rupees 10,000, and with which they will be able to purchase land and go back to their home. Now everything is complete. All the genuinely affected persons, they have received their respective relief grant, and by now, my lord, by a fact of time, my lord, all the relief camps have been closed and life has become normalized. But this is how the matter stands. They are still claiming, my lord, that they are entitled to relief grant.
Yeah, 32,
To the relief grant of rupees 10,000.
50,000.
50,000.
50,000.
So 50,000 at no point of time, my lord, the government, my lord, they had taken a decision. Of course, my lord, with regard to those persons who were severely affected and who could not go back, my lord, and whose lands were, my lord, lost, they were given 50,000, my lord, and so that they will be able to purchase, my lord, land with that amount, and they can, my lord, have a, my lord, dignified way of living. So this is how, my lord, it is with regard to, my lord, implementation of a government policy. The state took a policy and it was implemented and everything is complete.
What is the order of the
my lord. Reported, my lord, 2015 4 GL. Paragraph number 30, my lord. Addicted to pay the, my lord, rupees 50,000 per family.
no, no, 50,000 is it in the equal of the damages who own the get any house, right?
Yes, my lord, that this petition was disposed of. Against that, my lord, the state has filed a writ appeal which is pending before the Honorable Division Bench. It was listed, my lord, day before yesterday.
So let this matter be listed along with that.
Can be listed, but here,
So
my lord,
that will be the I letter, the judgment of upper
but that is not specifically pleaded out there. They have set up their own independent case where we have filed an affidavit. So you can take a call if otherwise not take.
we are thinking about the judgment. It's getting the judgment. Then why this matter? I put
Now we consistent keep this adjourn this matter for 4 weeks, my lord. Let waiting for the outcome of the division because, my lord, The Honorable Justice Manojit Bhuya had passed the initial order. That is, of course, a detail, it is a judgment. It ends that, my lord, the writ appeal number 233 of 2018 filed by the state, it is pending before the division bench.
How do you expect that it has here put
Because my lord, there was a delay. There was a delay, and my lord, my lord,
then also
condonation of
2018,
delay, my lord, condonation of delay, it
but
took some time.
then also it's a 2018. The
2018,
numbering of the appeal only happened after the condoning the date.
Yeah.
Does that
yes, yes. And then, my lord, after passing of the judgment, the Honorable Justice Manojit Bhuya, and then he was my lord, Honorable Justice Michael Dasankuma also passed a similar order.
And
In the line of that, no, there, my lord, the state stated it can be disposed of. Now we have filed another appeal, my lord, to that against that order also. Now two appeals, WA 233 and WA 320 of 2018. Both these three appeals are tagged together, and those are pending.
let us
my-
see the policy.
Yes.
Where is the policy?
Yes.
Where is the policy?
If Lordship may be pleased to take up the affidavit,
I'll be response number 6.
yes, my lord.
Huh?
Affidavit in opposition, my lord.
I'll be response number 6.
Filed by respondent number 2. The department, revenue department. Here, my lord, the revenue department is the administrative department.
Even if it is Koprada,
My lord,
even if it is Koprada.
yes, it was a decision of the state government, my lord. Because BTC is now BTC is, my lord, a sixth scheduled area. At that
Yeah.
area, it is by, my lord, one Pandindranath Chakraborty.
Huh?
That affidavit is by one Pandindranath Chakraborty.
It is the
Lordship may be pleased to come to paragraph 10.
it,
Lordship may be paragraph 10, my lord.
you are living in your own village.
No, my lord.
Where?
My lord, after here and there, my lord, after my lord, rehabilitation, my lord, after my lord, he allotted the land, my lord.
You got your
but
land.
it is eroded by the river, my lord.
That is,
That is another aspect.
that is not
And-
new cause of action.
Huh?
That will amount to a new cause of.
And that land
Where,
has
my lord,
been-
No,
whether,
this has nothing to do.
yes,
Yes.
whether.
You are erosion affected. Your erosion affected. You have to apply as per the net worth thing.
And my lord, in similar circumstances, my lord, the respondent paid the, my lord, 50,000 amount.
No,
my
no,
lord, finally
50,000 has only been
50,000
paid
with
to
an
those
arising out of
camp
ethnic
dwellers,
place, yes.
Only the
Ethnic place and
camp
erosion.
not others.
Yes.
Because what has happened out here, there were four types of groups. The food group were allowed to reside out there because they were forest dwellers. They were apparently it became burdensome for the government to keep them for a day. And as such was decided that to pay 50,000 and growth in 38 growth.
Yes, my lord, yes, yes.
And now if you look up in the happy that the permanent type and those that affected first very much side, they will sleep. If they have that, how that report is very now they have to take it. If they have to take it, really they
We have a notification also to that effect.
my lord,
I
recently, my
don't
lord,
have any other matter. I get quite my time.
My lord, it has called out the class of the better, what is it?
Yeah, I'm pretty put up with the fact that only 7 matters have been given 1950.
We are obliged always, my lord.
And I don't have a seat. Nothing.
and my lord, recently, my lord, the government, my lord, asked the, my lord, deputy commissioner to submit proposal. My lord. Accordingly, my lord,
Government will
Government,
do
my
what
lord,
you think. That is for the
yeah.
government. Oh, before the government, what is it? But this is what I take them grant a lot to do. Best court can say that okay, they are erosion affected, but they will apply it, get it. Now
Okay.
this everything has to be applied according to the application.
and
One
now, my
bad
lord,
very and 50,000 you cannot get.
Yes,
And-
it doesn't fall within any of the category.
my lord, subsequently, the concerned circle will stated that, my lord, no land, my lord, available to grant the petitioner. That's why, my
Wait
lord,
for
at
the-
that time, my lord,
Wait
I
for the
have
river changing its. Wait,
and my lord, in similar
And my lord,
circumstances, my lord, the government
rehabilitation
sanctioned.
policy is applicable to the entire state of Assam. Lordship has come across such kind of matters. In fact, Lordship has passed a positive direction. My lord, there was one case, my lord, Lordship will remember, my lord, it started from Dhamati. There, my lord, the land was eroded. Lordship has passed the direction that they will apply, my lord. If no land is found in Dhamati, maybe, my lord, they will be rehabilitated in any other district because it is Pan Assam policy. But we cannot compel the government that no, within that district itself I have to be rehabilitated. That will be against the letter and spirit of the land policy of 2019 itself. So this is directed.
And my lord, finally step annexer 3, my lord. On the similar situation, my lord. The government sanctioned, my lord, 50,000 per family, my lord. Finally step is 29, my lord.
no, they were camp dwellers.
That is discriminate, my lord.
Very camp dwellers. No, it is
In-
only the
Yes.
remove. You see, the government was defending the tax. They had no other way. In them out there was a huge financial burden. And then the government could let us get away with it by paying
My lord, to purchase the land, my lord, 50,000 to purchase the land, my lord.
not there.
And-
Those people who were camp dwellers. They're
Yes,
not a camp dweller.
yes. And it is precisely, my lord, only on those findings, my lord, with all aspects, my lord, of the lauded coordinated bench, my lord, we have put up that LBW. Because the provisions of Disaster Management Act 2005 was roped in, my lord. We said that no, that cannot be roped in. This is, of course, my lord, setting before the disaster. This was the,
Disaster.
that cannot be roped in.
Then also you have some things like the disaster mandate also.
My lord.
You also I those type of people, they take it. They were 5 Let's say somebody was
My honor.
if somebody burned
Well,
somebody's house also and me, then also do I
that-
this sounds applicable stuff.
And those repetitions also, my lord, issues were exactly identical. We say, my lord, that those
I
were-
thought
the repetitions do
that
not
those
come
type of
within
restrictions
the
are more
ambit of-
profitable. Why are you taking 50,000? Get money.
Because my lord, at that point of time, my lord, in the year 2010, my lord, 50,000 per family was already paid to the some sets of families, my lord.
That's
But
what, my lord,
those
he-
people who were
repetition
given by
doesn't
10
come
percent,
within that class of, my lord, beneficiaries. It is our submission, my lord, of course, but it is controverted by Leonard and we say that, my lord, the petitioners does not come within the ambit of that class of category, and it is a question of fact.
Yeah.
That is the admitted position.
it's a birthday, Wednesday,
So Steve has already given him the hint. So Steve has already given him the hint. He will be able to secure more relief to the petition.
That is a much better. And the leading counsel out there is Mr. M.A. Singh. The leading counsel. That's the big city. But the problem arises there. Government has been issuing notifications, whatnot. But at the end of the day, the problem is being faced out there by the legal service authority. There's the government, as of now, that I put together in view of the victim property. The amount that is to be paid now is something around 34 crores. Or 130,
This is the aggregate amount of claim.
only 23 crores have been paid. Now there's a huge problem. Orders being passed by this court, they are not supposed to. So the government has not, the government doesn't also have to take in the state. It have to. That's a huge problem with that. And there are many over, as I taking bench 4 at 5, there are very overlapping schemes.
Yes.
Person is not only entitled here, he may be entitled to that and gain another. Just for example, were there, he applied under the AERC and got pulled at.
Yes.
Then he comes under the public institute, public case,
Participate.
and again comes, applies here.
Yes.
The defending this court held that it's not a public.
Not a public.
And in fact, the interpretation given, I say that you must have got that,
Yes, 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 yes.
where you have to refer to some notification as well as that is record.
Because the second
But I think,
project mandate.
but I think if we look into the court judgment
Yes.
on public place,
Yes.
it makes it clear.
Yes.
It cannot be all the states.
Absolutely. In fact, my lord, the person to my lord's decision we have communicated, and now my lord, that 15/11/2014 notification, which provides for my lord grant of rupees 2 lakh in case of public motor accident in any public place, that has been revisited. Now, my lord, only those cases, my lord, where my lord,
No, that is not motor accident, not a motor accident.
not motor accident, but
No, here that case was that this person could see.
yes,
In fact, your earlier notification, which I held that notification would not hold the pin in respect of 15/11/2015 because that notification was earlier.
and
But from that notification, public place is, if you see that place also is a public,
which
meaning
is-
thereby this will be the public place.
which is visible in public. That was the precise wording.
But I said no,
Yeah.
that would not come because
we
if
have-
you see
yeah.
the Supreme Court judgment,
Absolutely, absolutely. We are obliged to my report. And in fact, my lord, after my lord order was communicated, my lord, the 23 recently, I think, my lord, in the month of November 23, they have come up with another notification. However, my lord, the categories of cases, my lord, all categories of cases, my lord, they have revisited it. Now only two categories differ. Only, my lord, the standalone person. If a person is standing on a public place, admittedly process, he is being hit and run cases. The vehicle comes, knocks him down, he dies, my lord, vehicle plays out. Then, my lord, 2 lakhs. And otherwise, my lord, for third
But
party.
what the bit? But that- yes, he's not getting it. Out of the vehicle under the vehicle that you make it, the state make it, but the public. But why otherwise?
Otherwise, because I had to also at one point of time, I had secured the original record to see the my lord policy making decision making process. What I found that my lord, it all started with it from the year 1994 or 96.
That is good, but what is the rationale behind? But if a person
same,
is
my lord.
otherwise getting it,
Yes, yes,
why the state?
yes, yes,
If he is not getting, fine.
absolutely.
In many cases, a person could not, that the truck could not be, a truck or bus could not be pissed off.
Yes.
The heated truck.
Yes.
Because
Yes.
nowadays, a particular people find a deep shit.
Yes.
So
Now-
let,
now-
let this new act come in. I think further require
Yes.
impose the penalty.
Now they have revisited it. Of course, I will be facing that it's not relevant notification with my
Because yes, a person does not get it, but if the car is identified, why should he get?
absolutely. Now that has been done away. Now only
Because
he can run.
after all, it's
Yes, yes.
has to understand that.
Basically,
money-
rationale behind what I found there was, my lord, the cabinet, in almost, my lord, all the nothings I found, my lord. The cabinet took a stand that being a welfare state, my lord, we should provide something. Initially, it
No.
was that,
Welfare state you provide, there's no quarrel. But if there is no, if he is not, doesn't get any other,
no, here, apparently they are getting double benefit.
they are getting for the motor
Yes,
vehicle
yes,
tax as
yes,
well
yes.
as here also.
Now that has been done away. After my lord had passed the decision, my lord, they have now revisited the notification. Now, my lord, so far as accident cases are concerned, only two categories remain: hit and run and third party. And if a third party person is there, my lord, who is
No,
not,
hit and run also.
Yes.
If that car is identified, then obviously he's entitled to the 50,000 initially and whatever may amount.
Yes.
But if he's not, if the car can't be identified, you give not 2 lakhs, you may even make it 5 lakhs.
Yes.
But yes, then he may be entitled.
Yes.
If that car is not identified. But otherwise, to give public money out here wouldn't, I don't think that may be prudent.
yes, that is. And now they are also trying to draw up a mechanism. In fact, they are doing it, my lord. That then in this kind of cases, my lord, accident cases, my lord, they are trying to draw up a mechanism whereby, my lord, they can get a state and control, my lord, over other, my lord, whether a person who, my lord, if he has secured rupees 2 lakh from the state, I mean, if he makes a MSP claim, my lord, whether that can be adjusted. The deputy commissioner has been
How
given
can
the
you adjust from whom? You can't adjust because of the fact that that amount,
will be paid by the insurance.
insurance
Yes,
or the person concerned.
yes.
And how can you adjust once the state pays the money?
Yes,
Can
no.
the state take that money from there?
No, my lord. Then one another situation is that, my lord, if it is found, my lord, that already a MSCP claim is pending, and despite of that, my lord, this claim, my lord, under this notification is also late. Then, my lord, the deputy commissioner will take a decision, and deputy commissioner will give a separate report to the government.
But in fact, nowadays, earlier it's okay. Earlier there used to be a lot of problems out there. But nowadays, you see the recent Motor Vehicles Act 19.
Now the quantum of no liability has also been, my
No,
lord,
not only that, the interesting party. Once an accident happens,
Yes.
the FIR being filed immediately goes to 3 places. One, to the insurance, if there is insurance. Number 2, it goes to the motor vehicle act, which is very relevant. So it goes to the motor vehicle tribunal, and the motor vehicle tribunal will make, then the role of the motor vehicle tribunal comes immediately. So the question of filing does not enter.
Yes. Yes.
Which is a very important factor.
Yes.
And if that be so, then in that case, The question of the government making any payment
Yes.
does not arise
Yes.
in view of that
Yes,
scheme.
Yes, correct. Because we will be getting double benefit, admitted.
Hmm.
We have time manager, my lord, communicated this aspect of the matter to the department. Somehow, my lord, this, my lord, amendment to that notification of late has come. And that again, my lord, they are retaining it, my lord, confining it to these two categories of persons, hit and run and third party. And other categories.
But
my lord,
hit and run, don't you think, has to be now looked in view of the amendment to the Central Motor Vehicle
Yes.
Rules 2019,
Yes.
which have come into effect.
Yes.
Now, with this effect,
Yes.
what is the cost? Yes, a person who has not got a single penny or nothing could be found out, then obviously can. But if a person has got that, and immediately nowadays, the moment an FIR is immediate goes,
Yes, yes.
the first place is it will go to the incident, second to the MHC, third to the what do you call that person to SSS. Na?
That is all.
So these are the three places it will immediately. Once it goes out there, then the question doesn't arise.
I have seen one of such set of cases was just maybe one of these to make some observations so that we can persuade the department.
Oh, my duty, this is not my part.
Lordship will kindly consider our practical difficulty. We communicate, but I cannot spell it out in open court. But if they find my lord a judicial declaration, my lord, they give more important. This is how my lord things are being run.
So your allotted plot of the, you were allotted plots of that,
my lord,
but that had
eroded,
eroded.
my lord,
So now you want some other plot.
my lord.
So
Or my lord,
then wouldn't you come within the ambit of erosion affected person and therefore you have to apply?
Well.
So you apply. I think that is the best option. There's no
but
way out.
the concerned circle officer stated that no land available to
That's
my
a
lord,
different thing.
accommodate the my lord petitioner.
No, if the land is not available, you can't apply. The land policy has to fall. See, the land can only be given if there is an excess land. So they will consider where to give or where not to give, whatever may have to shift from here and come back to Guwahati. It may not be there.
That's how my lord.
It may at best be a blessing in disguise. Chalo, देखो. The instant writ petition has been filed by an association. Association or committee?
Association
Registered
committee, my lord. Registered
By a registered society
society.
espousing the cause of 4285 big families who were allotted land by the government, but such lands which were allotted have been eroded by floods, caused by the river Torabhanga, I, Pompa, bracket, Bhur, Kumguri, and further seeking a rehabilitation of rupees 50,000 per victim family of the petitioner for the purpose of purchase of land of the construction of houses as the similarly situated victim family already received the same.
purchasing the land.
This court from a perusal of the writ petition, it revealed that the petitioner themselves admit that they were allotted lands. However, the such lands have been eroded in view of the river changing its course. Is it? Therefore, these petitioners could come within the ambit of erosion affected practice. In fact, that day I was discussing the thing, that judgment I delivered MA6 yesterday.
Yes.
I was looking for this. I was not finding it. It is there in point 5. Persons belonging to T and XT garden community will be given preference in allotment of land acquired from the T states under square. So that I was searching whether it is rule 17, 18, 19, or not find, because I remember reading it somewhere, but it is here now, because this is specifically for disposal of land of fixation. In fact, that judgment I will have to incorporate.
I apologize, my lord, I could not assist.
No, this is the thing. I will put it in
Yes,
that
yes.
judgment. This aspect. Number 2, clause 2.
Yes.
The clause 2 now will have an important bearing out there.
Yes.
In that case also, because that was a case of Assam Fixation of Land Ceiling Act, it was acquired 9 bigas or something. So if they are entitled to, not only it will be in terms of 17, but also where is erosion affected?
Yes, my lord.
So report, my lord, case 48. Circle of the report. Case 48.
And Uttam, within the ambit of clause 1.7 of the land policy of 2019. (1.7) (a) of the land policy of 2000. However, for the grant of settlement, the petitioners, the members of the petitioner society would be required to apply in terms with the settlement rules framed under the Assam Land and Revenue Regulation 1886, as well as the land policy of 2019. It is the opinion of the court that taking into account the, where is that circle of the,
My lord, 48, my lord, case 48.
taking into account the
Circle of the
the report dated 24/10/2013 of the Circular Officer Kokrajhar Revenue Service.
that given reply grant as well.
No. That you are landless where erosion, your lands have been eroded where is the report? There is nothing.
My lord, last table, my lord, last, my lord, subsequent table given reply and thanks for all my The land where they were rehabilitated was government farmland and land was not officially handed over and allotted in their name. However, in 1997, Saralbanga River eroded the area where they were rehabilitated. Therefore, he had to leave that place and forced to take shelter at different places. Some of them are settling in the neighboring district like Sirang. Due to ethnic test, Circle Officer report Kokrajhar Revenue Service. Thereafter, case 49, Gautama Register.
So how do you come within it?
The cycle officer is, my lord, drawing an analogy, my lord, from the
No,
earlier
But
policy.
how do you come with it? Okay, relaxing. Yeah. That if the petitioners are erosion affected first, if the members of the petitioner, if are erosion affected, they would be entitled to make necessary application as per the provisions of law, as above stated. And upon making such application, the respondent authorities are also required to consider the same in view of the land policy of 2019.
Yes.
Accordingly, this court grants the liberty to the members of the petition association to respectively apply for allotment of land in terms with the land policy of 2019. And if so applied, the respondent apply before the concerned deputy commissioner,
No, my lord, it will be BTC, it is sixth schedule area. Lord,
before the revenue secretary.
my lord,
All are 6 scheduled
Well,
before the revenue secretary.
yeah, it will be, my lord, the secretary, land revenue and DM department, board and territorial correspondent 5 years.
And upon application, the state authority shall duly decide the entitlement of the petition of the members of the petition association in accordance with the provision in terms with the land policy of 2019. Within a period of 11 months from the date of such application. The second aspect in the writ petition, the second relief for thought partner, the above therefore takes care of the first relief so sought for in the writ petition. As regards the second relief which have been sought for, that is for a direction to pay a rehabilitation grant of rupees 50,000 per victim, per
family.
per victim family of the petitioner. This court finds it very pertinent to observe, pertinent to take note of the affidavit filed by the respondent number 2, wherein it has been mentioned
My lord,
that
this court,
in case of families affected in 1996 and 1998 violence, the government prepared a 4-phase action plan. The various phases have been mentioned in a tabulated form, which is quoted hereunder. It was mentioned The people who were there in phase 1, 2, and 3 were rehabilitated. However, as regards the people who were in phase 4, for whom land had to be arranged, they continued to live in the relief camp. The government, in spite of great difficulty, could not rehabilitate these families. And under such circumstances, the maintenance of the said relief camp became burdensome for the government in view of the financial involvement and other issues in the domain of human rights. Under such circumstances, it was decided in a meeting held on 27/5/2009 that the General Council for Society for Rehabilitation of Violence Affected Families in the relief camps of Bongaigaon and erstwhile Kokrajhar district therefore decided in the meeting held on 27 that the Chief Minister of Assam would decide the quantum as a one-time lump sum financial assistance to be provided to each family as full and final rehabilitation grant. Accordingly, the government of Assam fixed rupees 50,000 as the lump sum rehabilitation grant per family, for which necessary funds were released and seven nine 51 families and 2096 families were rehabilitated. It is, however, seen that the petitioners do not fall within the said group. Under such circumstances, the question of directing the respondent authorities to sanction rupees 50,000 for rehabilitation of the petitioner, members of the petitioner association, does not arise. This court, however, they fall within phase 1, 2, and 3. Yes. This court, however, cannot be unmindful of the fact that the victims in the phase 4 were rehabilitated in view of the fact that the land could not be allotted to them in spite of best efforts by the state government. It is an admitted fact that the petitioners, members of the petitioner association, fall within the ambit of the people in phase 1, 2, and 3, and were granted allotment. However, if such lands were allotted to the petitioner, members of the petitioner association, and such land have already been eroded, the members of the petitioner association would come within, would fall within the same category as that of phase 4. Under such circumstances, the court observes the direct that in the eventuality, after making application by the members of the petitioner association, the government is of the opinion that such members of the petitioner association cannot be accommodated, cannot be allotted or settled any land. Then the government then the revenue and disaster management of the government of Assam has to take a call as to how the petitioner, members of the petitioner association, could be rehabilitated. This aspect, however, would fall absolutely within the executive domain. And as such, this court at this stage would not like to pass any directions. However, this court, however, observed and believed that the state of Assam, and more particularly the Revenue and Disaster Management Department of the Government of Assam, shall take a due call as to how the members of the petitioner association can be rehabilitated if lands cannot be allotted pursuant to the filing of the application. The members of the petitioners herein are given the liberty to approach the respondent authorities, and more particularly the Commissioner and Secretary.
No, madam, it will be the
Revenue.
respondent number 5, land, the secretary, land revenue, DM department, BTC.
Not for capital, for the
My lord, respondent number 2.
No, madam, after, my lord, it is found that they should not be rehabilitated.
then they will submit a representative.
No, they can, my lord, BTC will submit a comprehensive report to the state. Okay. That it come from the BTC.
That it took
Because they will be required, my lord, only to submit their application in a single
I
window.
know that that they would let them file a representative at that point. If they are not, I'll say the PTC will also give a and their report and their representation shall be cross-verified with the report by the PTC. That I'll give. But they will submit a representation to whom if the land cannot be allocated.
Yes, my lord, to the deputy commissioner. Deputy commissioner will, my lord, consider all the applications, my lord. He will do a preliminary verification exercise. And whether they are,
The concerned deputy commissioner of
my lord, it will be Kokrajhar.
all our
Kokrajhar,
Kokrajhar.
Chirang, 2 district.
Huh?
2 district, my lord. Kokrajhar, Chirang.
Chirang and Kokrajhar both.
could submit representation to the concerned deputy commissioner. Of the district where the members of the petitioner association reside present, who shall duly forward the same to the
My lord, to the revenue and disaster management.
to the Revenue and Disaster Management Department of the Government of Assam
For taking a decision.
for taking a decision as to how the members of the petitioner association could be rehabilitated. In doing so, the Revenue and Management Department, Revenue and Disaster Management Department of the Government of Assam shall also cross-verify with the Revenue Secretary of the petition
Yes.
as to the availability of land for settlement and whether the members of the petitioner association could not be settled in spite of application for lack of availability of land.
People may not use the word settlement, let it be allotment, because we do not know whether they were not patata or not. They may not be settlement holders, but they may be enforced by government. Allotment.
No, they were allotted.
They were allotted.
So once they are allotted, the land has gone away. So therefore, they fall within the once if you can't rehabilitate, you cannot grant them separate of any other land, but
They become
then
land
they
estate.
come within the space of phase 4,
Yes, land.
and for which then they will be after this 11 months is expired, they will submit with the
And my lord, may also direct my lord, state of my lord, the petitioner association filing a representation, let it be individual representation.
I see.
Individual. If there are
The petitioner says, no, no,
1,000 families, 1,000 applications. No, my lord, that is required, my lord.
because
Rehabilitation is more
rehabilitation, yes. Otherwise,
There
they
may be, my lord,
individual.
for one family, my lord, there may be 10 applications, we do not know. my lord. So it will be burden, my lord.
Again, there will be again lot of problems. So
Yes, burden.
whoever families have not been done,
Individual
the
application.
aggrieved in the word used will be not the petition association, the aggrieved members of the petition association who have not been granted allotment pursuant to their application will file a submit report.
Exist my lord, individual families, my lord, individual families, because it will come as a family. It will come as a family.
So that only you are going to keep the packet case for that.
Family. So for one family, there will be one application, likewise, my lord.
Aggrieved.
Ex-
Whoever,
ex-
you see, first they have to make their allotment application. If
allotment
they
application.
don't dare, whoever does it, then only they can.
Even my lord, at the very first instance also, when they are going to file a
I
representation,
said respective.
they expect
I
it.
tell them,
My lord, my lord, with all respect, my lord, if it can be, my lord, subject to lawsuit correction. My lord, individual applications by is affected family. Is affected family. The petitioner association will be there to enforce their cause.
no, I'm not saying about that. I said respective members of the petitioner.
Because there may be, my lord,
4852.
the 4852, but my lord, there are situations, my lord,
No,
where
that you
Ten-
will consider.
ten-
How
10
many
members-
people are there?
10 members constitute one family. So therefore, if 10 applications are filed, my lord, then those 10 applications will have to be attended to. Because each application will
No,
be attended
or we
to,
can put it
my lord.
respective members of the petitioner association who were earlier shall. Then it will already
Yes,
be
yes, yes. And my lord,
respect.
earlier allotted,
Left. Shall by.
my lord, yes, each application may, my lord, be enclosed with copy of my lord's order.
The one order who have.
No, one or 10, my lord,
You see, these people are
okay, my lord.
fighting for 50,000 rupees and you are now
No, my lord,
saying all
yes,
this
yes.
thing. Where will he go?
My lord, the credential,
Mr. K.R. Pateri, we shall bear the cost of all
no, my
certificate
lord,
copies of
understand that.
4,800.
My lord, the credentials, my lord, credentials. The fact that they were allotted earlier has to be brought to the knowledge of the authority.
Along with the-
Credentials, only one word, my lord.
Along with the
Credentials.
detectives that they were.
Credential is the,
And that I will make along with the.
my lord, my lord. And I'm so obliged.
Obliged.
The order filling is at these 28. These 28. In fact, there are three orders, these 28, 29, and 30. The petitioner is the owner of a house, one building, and there are three holding of it, ground floor, first floor, and second. So Mr. Kanak Chaudhary, he has expired and substitution has been made.
What has happened in the meantime?
Nothing has happened. In fact, they have not taken any action, and
There is no stay.
but we believe that there was a stay and there are some orders extending the interim order. But and
Now it is for that year. What is happening subsequent?
subsequently thereafter there is no communication.
So there is no payment of any holding.
No,
We have
no,
not paid.
they have not received the payment. That was one of my grievance.
And there is no bill issued after 2014.
Nothing has been there also citing.
It is quarterly paid. Then what's that?
Perhaps they are also, my lord, thinking that there is a stay order, therefore. that they have-
Anyway, the- you are telling
This order,
me that
by this order, your lordship will see that clause A. Let me read from there. Whereas the undersigned proposes to make an amendment under section 158 of the GMC Act 1968 by inserting there your name and your above mentioned premises at aforesaid rateable value from rupees 9657, 9,675 to 94,859. Now, the last paragraph. So this is to inform you that 30 days notice under section 158 of the GMT Act is hereby given, and the state alteration will be given effect to after the expiry of the state period. If you have any objection, you may do so. Now, bottom, your lordship will kindly see property tax, then annual urban immovable property tax to rupees such and such with effect from second quarter of 2008-2009. Because, my lord, under the act, it can be only from the year of this reassessment. There cannot be retrospectivity. Now, the other orders are similar in nature. From 7,800 to it has been increased to 1,15,000. Then from 17,055, 7,550 to 2,26,811. The petitioner filed his objection.
after I
Submitted reply, objection has been filed that your lordship will find at page 31. There he has taken these grounds. If your lordship comes to page 38, paragraph 3, that the petitioner says that upon receipt of the said notice, there is showing the petitioner has become astonished as to how the existing rateable value of 9 has increased. The petitioner says that under section 150 of the GMT Act, the rateable value of the land and the building accessible to property taxes shall be the annual rent at which the land and building might reasonably be expected to late from year to year. As per proviso made under section 150, the rateable value thereof shall not exceed the annual amount of standard rent so fixed under the Assam Urban Areas Rent Control Act.
where is this AKR plan?
That is near for
When were the rateable value?
annual. That was 9,675. That is in the imperial order itself. Is 28.
No. When was the peak?
That has to be the ground floor was of 1955, first floor 1974, second floor 1989, third floor was constructed in 1991. So it has to be 74, 90 and 90.
Huh?
1974, 1990 and 1991.
So 1974.
Second
the rateable
floor
value.
is the ground floor. The ground.
That's the rateable value is taken from the fixed standard rent.
Standard
12
rate.
months.
Yes.
Now AKR so
No, no. Naturally, there has to be, there has to be an upgradation of the figure. That is, there is no dispute to that, but it has to be on the basis of this, the provision which says that it cannot exceed the 150 year or kindly see. It says 158 subsection 158(1) proviso. Provided that no person shall, by reason of any such amendment, become liable to pay any tax or increase of tax in respect of any period prior to the commencement of the year in which the amendment is made.
So they were asking for the earlier petition.
They were asking for 2008 onwards. The bottom of the impugn orders.
This rateable value was fixed. In which again
There are three holdings. One is 153,
the one A 15,000. This was done in 1989. Only come to page 49.
Page?
49.
Right.
Down below.
Yes.
Annual rateable value.
This was done in nine. Second. That was the second floor was constructed in 1918.
No, that is the annual rateable value was fixed in the year 1989.
Yes.
Because if you see that particular signature is of 1990.
78, 1990.
Because the value of the land have increased manifold.
That is right. There is no dispute to that.
Page 54. 54. We are concerned with AK Azad Road. So 3,50,000, now it has become 10 lakh. Main road and Bylane motorable is 7,50,000. And this is 4 lakh. But I don't understand, and now it has not again increased. So this amendment has already been made. Amendment made since when? This amendment was made in which year?
2002 quarter.
14. We have made the amendment from 2014. How?
It is 56, it is second quarter of quarter.
So you did the reassessment in 2008-9. Yeah, that I've seen it, page number 60. Page number 60, page number 57. No, kindly come to page number 57. On top, with effect from, this is reassessment done with effect from second quarter of 2008-9. When was this done? Assessment? Now, prior to the assessment, are you not required to issue notice?
They are required.
How do you do it? 158.2. Section 158.2 envisages issuance of notice. And if the notice was issued in the year 2014, can you make it prior to that? So the assessment has to be prior to that, cannot be prior to that. So the amount can be very well calculated. Yes, you can very well do it. After 2000, after issuance of notice and taking a decision, not prior to that. How can you do it for assessment? How can you make that assessment for that quarter of 2008-9 when you issued the notice only in 2014? Huh? No. How can you say it area? This is a notice under 158. No. So this is to inform you that 30 days notice under 158 is hereby given that the state authorization of year will be given effective after the expiry of the state period. This is the notice. This is the notice under 158 too. And under such circumstances, if this is the notice under 158 too, you can very well effect. But after this, otherwise, what is the meaning of the 158 too? Can you have it for 2008-9? No, you can have it post 2000 after the notice. So the question of touching on the valuation assessment made by you, this court is not inclined. But the fact that it has to be only post the notice, post the decision taken, the notice.
And after hearing the objection, and after the objection is taken note of.
Now you have given the objection and then they have done it.
Without
So
giving
their
any-
objection, then when did they have done it? Pursuant to the objection. Was there any stay? There is no stay. So when did you decide? That is why you have issued the notice. Let us see 158. Before making any amendment under subsection 1, the commissioner shall give to the person affected by the amendment notice of not less than 1 month that he proposes to make amendment and consider any objections which may be made. Meaning thereby, there is a concept of consideration of the objection. So once that objection is being filed, what have you done? Have you taken a decision after the objection or prior to that? What is your reply? Huh? Let us see your reply.
reply, we have given one.
Submitted objection in response to the objection has informed the petitioner by the
852.
communication that they take the deed, stating that the reassessment has been done. Now, therefore, you can do it very well from 11/3/2015, Annexure D. Page Annexure D.
At least 49.
With reference time to enclose here with the reassessment date. So this has been done on 11/3/2015.
In paragraph 6 of their affidavit, we have taken the ground that in response to the above objection, BMC has informed the petitioner by letter dated 11/3/2015, stating that the reassessment has been done as per order dated 12/8.
It's okay. They have done the reassessment as on 11/3/2015. So the assessment list will only alter, can only be altered after 11/3/2015, not prior to that. So it has to be prospectively. But you can't demand prior to that. Did you demand prior to that? Huh? $28. Yeah. No, 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 no. You see, whatever may, the Act categorically maintains that the assessment list can only be altered by giving notice. They have given notice. You have given notice. They have submitted an objection. You have decided in 2015. So with effect from 11/3/2015, that is the as per your paragraph 6, it will be deemed to have been altered. So only for that period onwards, you can very well take it, not prior to that.
But then the objection that has not been considered if the order which is given to subsequent to the objection.
In fact, it should have been more increased. At the time when you were taking into account, the value of the property must have gone much more. No, no, understood. At that time, yeah. But in fact, in 2015, when you consider also, the value must have gone down. In fact, you should have increased it more.
They could have.
So post 2015, this court is not going to touch. You can take, but not prior to touch.
Your Worship will kindly peruse the communication at page 52. That does not deal with the objection.
Page
52.
Yeah.
Subject reassessment. With reference to the subject cited above, I am to inform you that the reassessment of the above mentioned holding have been done in accordance with this office order to the going.
Yeah, there is only a requirement of consideration. They have considered your thing, but they have done it as per that particular document at the value of the property and the rateable value. And if you are aggrieved, file an appeal. Go and file an appeal. That is an administrative decision which they are to take. If they have taken it on the administrative decision, it has to be on the basis of the value of existing at that point of time. In fact, this communication was of 2008.
That event your Worship with the draft of liberty to file
What a bit.
change this order at
Okay, we don't touch anything. I give you liberty to file a appeal. File a appeal. I'm not going to touch anything. But on that I can give it. But I'm not going to touch anything and say that you are entitled to file a appeal. In fact, I may record out here that it is less. As on 2015, the value must have gone up many times. And this has been done in 2000. Right? And every year, in fact, this assessment value, if you see, is to be carried out every year,
because it increases every year.
which
That's
is
right.
not being done. So under such circumstances, that is why there is a lot of stagnation and the poverty of the GMC to pay.
Revenue collection is that's why.
That is the reason why the Act mandates every year to do. You are not doing it. But as per the Act, you can't have it prior to that. So it has to be from 11/3/2015. This assessment would only be effective with effect from 11/3/2015, not prior for any prior. Yes, Mr. Chaudhary, you want that order or want to file an appeal?
No, like it. I would have loved to see this out.
Okay.
Because it is always open to file
Huh?
the appeal or not, that will be another.
The petitioner herein the original petitioner herein, Sri Kanak Chaudhary, was the owner of three holdings.
I've given the holding number in this.
The
set of
holding
this.
number 31, 153, and 31A of ward number 22 of the Guwahati Municipal Corporation. In the year 1990, in the year 1990, the annual rateable value for holding number 31 was assessed at rupees 17,550. In respect to the holding number 153, the annual rateable value was assessed at rupees 77,810. And in respect of holding number 31A, the annual rateable value was fixed at rupees 9,675. The record revealed that the commissioner of the Guwahati Municipal Corporation had issued a communication on 12/9/2008 to all the deputy commissioners of the Guwahati Municipal Corporation to implement fresh assessment for property tax, including reassessment with effect from the second quarter of 2008-9. The land valuation during the land valuation, which was prepared by which was fixed by the Deputy Commissioner Kamrup Metro, was enclosed to the said communication. It is relevant to take note of that in respect of AK Azad Road, which falls in ward number, which fell earlier in ward number 22 and thereafter ward number 32. The value of the land had increased manifold. For example, in the main road of for example, AK Azad main road, the land value, which was 3,50,000, became 10 lakhs. The bylines which were motorable, which was 1,50,000, became 7,50,000. And the bylines which were not motorable, which was 80,000, became 4 lakhs. the GMC authorities. More particularly, the Deputy Commissioner. The concerned Deputy Commissioner woke up almost after 6 years. From the date of the communication dated 12/9/2008, and issued notices to the petitioner in terms with section 158(3), 58(2) of the Guwahati Municipal Corporation Act 1971, for short, the Act of 1971. In the said notices, it was proposed that the annual rateable value for holding number 31A which became or 38, 31A bracket pole oblique 108 5425 0 new, which was 7,100 810, would be rupees 1,15,124. In respect to holding number 31 old 10852,040 new, the annual rateable value, which was 17,500, was proposed to be rupees 2,26,811. And in respect to holding number 153 old, 10853,270 new, the annual rateable value, which was rupees 9,675, would be 94,859. The petitioner herein the original petitioner herein was directed to submit his objection, if any, to the amendment of the assessment list. The record reveals that the original petitioner duly submitted objections and thereupon on 11/3/2015, the commissioner of the Guwahati Municipal Corporation informed the petitioner about the reassessment done to his holdings and the petitioner was directed to pay the property tax fixed as per the reassessment. Petitioner thereupon had challenged the reassessments so made to its holdings by way of filing the instant risk petition. This court, though, issued notice, but there was no stay order so passed. During the course of the hearing, this court duly inquired with the learned counsel appearing on behalf of the petitioner as well as the respondent as to what is the present position, taking into account that there was no stay order passed, and as to whether any future bills have been issued pursuant to the reassessment of the holdings in question. It has been submitted to the bar that in view of the pendency of the instant writ petition, nothing has been done so. This court have duly heard, it further seems from the records that there is an affidavit in opposition filed by the respondent number 1, 2, and 3. This court finds it relevant to take note of paragraph number 6 of the said affidavit in opposition, and the same is reproduced hereunder. From the above quoted paragraph, it would reveal that the petitioner was allowed to submit objection, and thereupon the petitioner submitted his objection on 3/1/2015. Subsequent thereto, on 11/3/2015, the petitioner was informed about the reassessment. In the backdrop of the above, the question therefore arises is, can the reassessment be made retrospective for the quarters 2008 and 9 when the notice was issued on 4/12/2014 in respect to the 3 holdings, and the petitioner, after filing the objection, was duly informed on 11/3/2015 about the reassessment? The answer to the same can be found from a perusal of section 158 of the Act of 1971, which empowers the commissioner, with the approval of the committee, to amend the assessment list at any time. This power, which has been conferred under subsection 1 of section 158, includes the power of increasing or reducing for adequate reasons the amount of any rateable value and also of the assessment thereupon. The proviso to subsection 1 of section 158 further mandates that no person shall, by reason of such amendment, become liable to pay any tax or increase of the tax in respect of any period prior to the commencement of the year in which the amendment is made. Subsection 2 of section 158 of the Act of 1971 is very relevant, taking into account that obligation has been cast upon the commissioner before making any amendment to give notice to the person affected by the amendment of not less than 1 month that he proposes to make the amendment, and after considering any objections which may be made by such person, make any amendment if deemed so necessary. In the instant case, it would be seen that it was only on 4/12/2014 that the notice was issued, and pursuant thereto, within 30 days, the petitioner duly submitted his objection on 3/1/2015. It was only on 11/3/2015 the petitioner was duly intimated about the reassessment made. Under such circumstances, it is the opinion of this court that the reassessment so made has to be made applicable only with effect from 11/3/2015 and not prior to that. Full stop. In that view of the matter, this court, in that view of the matter, this court therefore declared that the assessment, that the reassessment of the petitioners in respect to the holding numbers shall be deemed to have been made with effect from 11/3/2015, and on the basis thereof, the respondent authorities, more particularly the GMC authority, the GMC authorities, would raise appropriate notices, demand notices for payment of the property tax. Full stop. With the above observations and directions, the instant petition stands disposed.
Highly object.
Today I've been given 7 matters, all finished.
What you have to sit for this matter only.
Huh?
Yeah. Only because of this matter.
This type of matters required to finish up. Earlier, if it was finished up, it would have been better.